morning, Mr. Brandon. My name is Rou Qi, a legal associate from PSA firm appointed by Ms. Buttery to submit a video presentation to critically evaluate the extent to which the current law of foreclosure, possession, or sale confer an appropriate balance between the interests of mortgagee and mortgagor. In addition, a conclusion as to which remedy is better will be provided at the end of this video. Please allow me to list the key issues identified in your case. Firstly, Mr. Brandon had mortgaged your house to Tough Bank, therefore a brief explanation on the loss of mortgage will be given. Next, since Mr. Brandon is looking for alternative to bankruptcy, the loss on other remedies will be explained in detail. Finally, taking into account Mr. Brandon's situation that the loan is upside down, you and your wife are working 3 jobs and paying your daughter's medical bill, I will also be assessing which remedy is better for you. The underlying nature of mortgage is once a mortgage, always a mortgage, mentioned in the Tom Burrough and Baker case. This means that every mortgagor should be able to get back the property once they finish paying the loan. Any other additional clauses are not able to prevent the mortgagor from redeeming the property loan, according to Johnson Morgan. However, if the mortgagor is unable to settle the outstanding loan, there are remedies for the mortgagee to claim back the outstanding amount, whereas the mortgagor would also have certain rights to protect themselves. Now, I'll be explaining the relevant rights that you own to protect you from being exploited from oppressive bargains and undue influence. Firstly, oppressive bargains usually related to fluctuation of interest rates. This can be seen in Cityland Properties and Deborah case, where the court held that the interest rate increase from 1% to 19% is considered as unconscionable and oppressive and should be struck out. Therefore, if the contract signed involve clauses that can raise interest rate to a high extent, that should be invalid. However, if the variation of interest rate is exercised in a rational way, as mentioned in Paragon Finance plc and Nash, then the clause is not invalid. In addition, if Mr. Brandon had experienced undue influence or fraud from the others as seen in Barclays Bank plc and O'Brien, the whole transaction would be set aside. This is mentioned because in the particular scenarios provided by Mr. Brandon, the bank manager had advised you to refinance twice and therefore has exerted influence in your decision making. However, this scenario itself is insufficient to prove undue influence. Therefore, if you have any other related information, please let us know. Without further ado, I will explain the remedies that Tough Bank might use in order to claim the loan owed. There are 5 remedies in total, including the right to appoint receiver, the right to foreclosure, the right to take possession, the right to sell the premises, and the right to sue the mortgagor on the personal covenant to repay the mortgage. According to Bristol and West plc and Bartlett, the mortgagee like Tough Bank can exercise more than one remedy at the same time. First of all, even though the right to appoint receiver is one of the remedies mentioned, it is not applicable in this case. This is because this right is usually used when mortgagor's premise involved is being leased to multiple tenants, because if the court allows foreclosure or right to possession, most of the tenants would be homeless. In addition, the tenants who fulfilled the formality of legal lease are all protected by the Rent Act. Therefore, to solve this problem, the alternative remedy would be appointing receiver to manage the property and to collect the rent and pay back to the mortgagee. Other than the right to appoint receiver, Tough Bank has the right to foreclosure. This is provided by Section 88 of the Law Property Act 1925 for freehold properties. Once this right is exercised by the bank, it will take over the house and become the outright owner. Usually, the bank will then sell it off at the auction. Under Section 91, Subsection 2 of LPA 1925, this right is not only owned by the bank, but owned by anyone interested at their request, including the mortgagor himself. However, due to the strict nature of the foreclosure, this right can only be exercised when the bank applies at court. Furthermore, as seen in Polk and Mortgage Services Funding plc, there are rarely any foreclosure actions brought about today because of its draconian nature that the property would be irredeemable once the property is foreclosed, and the need to balance between the rights of mortgagor and the mortgagee. Therefore, to exercise this right, Tough Bank will have to provide a very strong reason in order to have a successful application. Even so, the court has the discretion to reopen the foreclosure if Mr. Brandon can provide sufficient evidence to prove that you can repay the full outstanding payment if extra time is given, as seen in Campbell and Holy Land. Given that the right to foreclosure is designed to protect the mortgagee's interests, it is often argued that the mortgagor's equity in the property is set aside. A detailed account of how exactly the right to foreclosure in American laws fails to strike the balance is given in the journal article by Alex M. Johnson. In it, he drew hypothetical facts from Murphy and Financial Development Corporation, where the bank was able to profit from the foreclosure sale transaction at the expense of the mortgagor. When the right to foreclosure is exercised, the bank will auction the property at a price that is just enough to pay off the debt, but not the market price. The problem is that not many retail purchasers will competitively bid because most notice of the auction will not be popularized because notice are only put up on the county courthouse. This reduces the number of bidders, therefore the bank will most likely be the purchaser at the lowest bid and sell it off at the market value, generating profit which the purchaser had an equity in but would not receive. However, this scenario is inapplicable in the UK since in mere brick company and mutual financial company, the bank must sell at least at market value and therefore it has relatively struck a better balance. Nevertheless, since foreclosure is against the nature of mortgage as the property becomes irredeemable and coupled with the case of POC and Mortgage Service Funding PLC, it becomes clear that the right of foreclosure will unlikely be exercised by the South Bank. The third type of rights that the mortgagee can exercise is the right to possession. The bank can take vacant possession of the house as an initiative to sell the house. In common law, the bank can at any time exercise their right to take possession as seen in Rupegila and Barclays Bank PLC, as soon as the mortgage is made as shown in 4 Mates Limited and Dudley Marshall Properties Limited. To exercise this right, the bank does not need to apply to the court unless they decide to sell the property. In reality, however, this right will only take place if Mr. Randon is unable to pay the mortgage. Fortunately, under Section 36 of the Administration of Justice Act 1970 and Section 8 of the Administration Act of Justice Act 1973, it was provided that the court can adjourn the proceedings of possession of the dwelling house provided that the mortgagor can repay the mortgage in a reasonable time. Therefore, if Mr. Brandon is able to give such evidence and satisfy the court, it is possible to adjourn the proceedings of possession as the court would definitely want to balance the interest between the mortgagor and mortgagee by providing temporary relief to the mortgagor who loan a residential premises because there are elderly or children in the premises. The duration given by the court to repay the loan is entirely the court's discretion as long as it is reasonable. For example, in Birmingham Citizen Permanent Building Society and Cont, the court had adjourned the proceedings to take possession of 28 days, whereas in Cheltenham GPS and Norgan, the court allowed the postponement of the possession proceedings for the entire term of contract, which is 13 years. This shows that there is definitely a possibility for us to apply for a longer period of postponement rather than the 90 days mentioned by the bank manager. Especially in Mr. Brandon's circumstances, your daughter's heart disease can be considered as urgent and exceptional. Plus, if you and your wife are having 3 jobs at the same time, there is a high possibility of getting a postponement for a longer period as it is not speculative as in Sylvan Properties and Royal Bank of Scotland. In addition, in the case of Mobil Oil Company and Robinson, suppose Mr. Brandon's case as it is mentioned that the relief is usually provided for occupational residential premises. Although it seems that the law has struck a balance, the critical analysis by Charles Harpham of how judges had interpreted Section 36 of the AJA 1970 using the mischief rule proved otherwise. In Western Bank and Sclander, Lord Justice Buckley and Lord Justice Carman added words onto Section 36 subsection 1 of the AJA 1970 to interpret it as only applying to mortgagors who failed to pay the loan instead of limiting the court's powers to postpone proceedings in general. In reality, as argued by Harpham, this interpretation lacks accuracy as the mischief that the law was trying to remedy was not clear in the first place. This has caused problem in applying Section 36 of AJA 1970 as now it is only limited to cases where the mortgagor was in default, the exact outcome that both Lord Justices sought to prevent initially. Thus, it can be concluded that the judges in general seek to give effective protection for mortgagor against the unreasonable exercise of mortgagee's right to possession, but this case has failed to do so and left a precedent for future courts to follow. We will now move on to another way of preventing the mortgagee from exercising the right to possession, which is intervention of equity as seen in Quinnell and Motley. In keeping a mortgagee out of possession, R.A. Pearce presented a contrast between Lord Danning's view with the conventional view. Lord Danning opined that as long as default is absent, equity has ample power to restrain the mortgagee from taking possession of the property. However, in Cont's case, Justice Russell stated that no principle of equity can interfere with the mortgagee's right. Thus, it was concluded by Pearce that the decision in Quinnell is to be justified on alternative grounds, implying that equity will not be able to keep the mortgagee out of possession, even in cases where there was no default. This suggests that law had yet to find a balance, as possession might be exercised fairly despite the mortgagor paying the debt. The fourth right that will be most likely to exercise by the bank is the right to sell the premises. All 3 conditions under Section 101 of LPA 1925 must be fulfilled for this right to arise. Once all conditions are fulfilled, Section 103 of LPA 1925 must be satisfied. Interestingly, both the mortgagee and mortgagor can apply for this right as provided under Section 91 subsection 2 of LPA 1925 and further supported by POC and Mortgage Services Funding PLC, but it was mentioned that the court had unfettered discretion to order a sale. However, caution has to be taken as the court may refuse to order pending of a sale even if it was insufficient to cover the debt if it feels that mortgagor is delaying matters as seen in Shettleham and Gloucester plc and Cross. The case of Lord Waring and London and Manchester Assurance Company Limited has provided that once a bank entered into a contract to sell the house, the mortgagor cannot start the proceedings even after paying off the debt. A downside to Mr. Brandon is that the bank is not obliged to find a sale in the interest of him. This means that the bank can sell the property at a lower price even though it could be sold at a higher price as seen in Mere Brick Company and Mutual Finance Company, where it was held that the only obligation of the bank is to at least sell at a market value, which will likely to be the appraisal figures provided by the county. This is disadvantageous to Mr. Brandon as this means that even after selling the house, he will still owe the bank money due to upside down payment mentioned in the scenario. Plus, under Section 105 LPA 1925, the proceeds of sales will first be used to pay off the costs involved in the sale and then only the loan. Only then the remaining amount will be given to Mr. Brandon. Thus, it is encouraged that Mr. Brandon applies for the right to sell if Mr. Brandon has found a buyer that is willing to buy the property at a greater value. Now, the right to sell allows the mortgagor to obtain profit from the sale and retains the mortgagee's right to recover the debt owed as soon as possible. The distribution of proceeds of sale under Section 105 LPA 1925 was also more structured as compared to the American counterparts. For example, it was mentioned in the journal article that the American court held in Skill and Law that after paying the debt and reasonable cost, the extra proceeds should go to the mortgagor. American laws are not as clear as LPA 1925, which defines the reasonable cost. A deeper analysis of this right is provided in the journal article by Matthew Conaglan. It was disputed that the court had arrived at its decision in the case of Williams and Glyn's Bank Limited and Boleyn because of social justice causes. Matthew believed that the court had merely literally interpreted the statute. His rebuttal was substantiated with Lord Wilberforce's speech that focused mainly on the application of the Land Registration Act 1925. Therefore, in cases where there are two owners of the mortgaged property and only one agreed to the mortgage, the court had depended on the relevant statute in arriving at its decision. This means that if statutes regarding the right to sell account for a wide range of scenarios, balance is struck. It was later mentioned that the LPA 1925 justifies the priority of mortgagee's interest over the co-owner in cases where the mortgage overreaches equitable co-ownership of the property. It can then be inferred that the UK statutes had prioritized the mortgagee over the mortgagor and vice versa depending on the circumstances. In short, a sufficient balance is achieved in the UK in regards to the right to sell. Lastly, it is likely that Taft Bank will sue Mr. Brandon on personal covenant. This is the right of the mortgagee to recoup the outstanding sum if the sale of property cannot cover the full amount of the debt which fits Mr. Brandon's case. For example, in Wilkinson and West Bromwich Building Society, the bank sued on personal covenant because there was a shortfall of £47,000 at the time after selling the property. Take note that the limitation period of exercise this right is 12 years, so Mr. Brandon should be aware of it in case Taft Bank failed to bring an action within the time period. In conclusion, Taft Bank will most likely first exercise the right to possession, then the right to sell the premises, and finally the right to sue on personal covenant to recover the full sum of debt owed by Mr. Brandon. These remedies are better because the circumstances that the right to possession failed to balance the mortgagor's interests are inapplicable in Mr. Brandon's case. Plus, by exercising the right to sell, Mr. Brandon can find a buyer of the house at a price equal to or more than that, thus preventing Mr. Brandon from being sued on personal covenant. If Mr. Brandon insists not to sell the house, the last resort is to convince the court to provide a longer period to repay the loan. That's all from me. Thank you.